In the matter of Boyd against Public Prosecution Service for Northern Ireland.
Lord Stevens will hand down the judgment.
This appeal concerns the circumstances in which a district judge in the Magistrates Court in Northern Ireland may reopen a case in which sentence has been passed in order to impose a different outcome. As the power to do so is found in Article 158A of the Magistrates Courts Northern Ireland Order 1981, the circumstances in which the power may be exercised turns on the correct interpretation of that article. On the 28th of June 2021, Lewis Boyd pleaded guilty to charges including criminal damage. The criminal damage was to a home. At the sentencing hearing, which occurred some 2 months later in August 2021, the Public Prosecution Service had not received a repair estimate from the home owner. Therefore, the district judge was unable to include in the sentence imposed on Mr. Boyd an order requiring him to pay compensation to the homeowner for the damage which had been caused. Such an order is called a compensation order. The district judge did not adjourn the sentencing exercise to obtain the details which would have allowed him to include a compensation order in the sentence to be imposed. Rather, the district judge proceeded to impose a probation order and a restraining order on Mr. Boyd. Some 1.5 years later, in April 2023, the prosecution applied for the sentence to be varied to include a compensation order requiring Mr. Boyd to pay compensation to the home owner. Article 158A provides that a district judge may only vary a sentence if it appears to the court to be in the interests of justice to do so. Mr. Boyd contended that to vary his sentence so long after it had been imposed was not in the interests of justice. He also contended that the district judge did not have jurisdiction under Article 158A to vary a sentence by imposing a compensation order in circumstances where a compensation order had not previously been imposed. This, it was submitted, would not be a variation, as there was no compensation order to vary. Despite these submissions, the district judge decided to vary the sentence by including a compensation order, requiring Mr. Boyd to pay compensation to the home owner. Thereafter, the points raised by Mr. Boyd were referred to the Court of Appeal by way of a case stated. The Court of Appeal held that a compensation order could not be a variation of a probation order or a restraining order. Therefore, the Court of Appeal held that the district judge erred in law by imposing a compensation order in circumstances where such an order had not previously been imposed. The Court of Appeal further held that the purpose of Article 158A was to correct mistakes in limited circumstances to avoid the need for additional proceedings. The Court of Appeal held that it was extremely difficult to envisage any case in which mistakes made by the prosecution would engage the power to make a variation, and that the decision by the court not to adjourn the proceedings was not a mistake just because it might have been better or more prudent to have acceded to an adjournment. The outcome in the Court of Appeal was that the order varying Mr. Boyd's sentence was made in error and was overturned. The Public Prosecution Service appeals to the Supreme Court. Before the Supreme Court, the Prosecution Service conceded that it was not in the interests of justice to vary the sentence imposed on Mr. Boyd, having regard to the period which had elapsed between the date of the sentence and the date of the application. The prosecution accordingly accepted that there should be no interference with the order of the Court of Appeal overturning the variation of the sentence imposed on Mr. Boyd. Even though the prosecution accepted, given the passage of time, that the district judge ought not to have varied the sentence imposed on Mr. Boyd, it asked the Supreme Court to rule on the correct interpretation of Article 158A. The Supreme Court considers it appropriate to do so because Article 158A is regularly used and the dispute between the parties about how it operates is not one which depends on the facts of this particular case. The Supreme Court, in a joint judgment given by me and Sir Declan Morgan, with which the other justices agree, unanimously decides that the Court of Appeal's interpretation of Article 158A is unduly narrow. The Court of Appeal was right to consider that the orders made by the district judge, including the compensation order, were individual elements of the sentence, but it was wrong to confine the power in Article 158A to a power only to vary those individual elements. The power to vary in Article 158A is a power to vary the sentence or other order, and this power includes the power to vary by addition. Indeed, the Court of Appeal's restriction on the use of the power to vary would give rise to absurdity. An order includes a refusal to make an order. In this case, the district judge did not make a compensation order. On the basis of the Court of Appeal's approach, if the district judge had refused to make a compensation order, it would then have been within the competence of the court to vary that refusal. But because he merely failed to make any order, there was no power to use the provision. The legislator, in enacting Article 158A, did not intend its interpretation to produce such an absurdity. The primary purpose of Article 158A is to provide a mechanism for the correction of mistakes that can be conveniently rectified in the Magistrates Court, thereby avoiding further proceedings by way of appeal or judicial review. Such errors can arise in various ways, including as a result of conduct by the prosecution, or as a result of the failure of the district judge to adjourn the sentencing hearing. The statutory purpose is not achieved by narrowing the nature of mistakes that can be addressed. In conclusion, the Court of Appeal's interpretation of Article 158A is unduly narrow, but the district judge erred in varying the sentence imposed on Mr. Boyd. The variation order made by the district judge remains quashed.
Thank you. The court is now adjourned.